Welcome to a panel discussion on the professional duty of lawyers and bar associations in action on climate. My name is John Dernbach, Professor Emeritus at Widener Commonwealth Law School in Harrisburg, Pennsylvania, and I moderated this program. It is sponsored by the American Bar Association, the International Bar Association, and the New York City Bar Association. Our point of departure is an article that I co-authored with Irma Russell and Matt Bogosian on the lawyer's duty of competence in a climate-imperiled world. This discussion is in two parts. The first is a recording of the panel discussion that occurred on September 23rd, 2024 at the New York City Bar Association. Unfortunately, as you will see, we had several additional speakers who are going to join us by Zoom, but who could not do it because of technical reasons. So what we've done is recorded their presentations, and you will see those as a second part at the end of the panel discussion. Thank you.
Hello, everyone. My name is Julie Kim, and I am one of the co-chairs of the New York City Bar Association's Environmental Law Committee, along with John Rousakis. John and I want to welcome you all to the City Bar. The City Bar was established in 1871 and now has over 100 committees that are engaged on issues of local, national, and international significance, including climate change. The Environmental Law Committee has been active for many years on climate change matters, including hosting an annual Earth Day Climate Change Symposium and preparing reports in collaboration with our colleagues and partners, many of whom are in this room tonight. You'll also hear from one of our members, Yvonne Norman, during tonight's discussion. In the past, we have also convened a conference attended by multiple stakeholders in the New York City metropolitan area to discuss opportunities to raise public awareness about climate change, and have since worked to call New Yorkers, law firms, and legal organizations to action. So you are in the right place, and today's program continues with a theme of action, this time on the professional duty of lawyers and bar associations in action on climate. We are very fortunate to have our panel discussion moderated by John Dernbach, Emeritus Professor of Law and former Director of Widener University Commonwealth Law School's Environmental Law and Sustainability Center. John is a nationally and internationally recognized authority on sustainable development, climate change, and environmental law. Before turning the program over to John, we would like to thank him for all of his hard work in bringing together this important panel during Climate Week, as well as the other sponsors of the program and the City Bar staff.
Well, thank you, Julie, and thank you for the kind words. Good night, everybody, or good evening. It's good to see you all here. We did a program like this last year, and it was more generally about what lawyers and bar associations should do. And what our object was last year was to highlight the cooperation you're beginning to see among bar associations, International Bar, some of the other national bars that you'll be hearing about, Brazil, UK, and elsewhere, along with the ABA and the International Bar Association. This year's program is a little different because we're focusing on professional duties. Since last year's, I just put up a different slide on the screen, which you may not be able to fully see, but I think you get the idea. We produced an article, Irma Russell, who's one of our speakers tonight, Matt Bogosian and I, where we anchored the responsibility of lawyers, not simply in, this is something that you ought to be considering, but in the professional duty of competence. And that's what we tried to focus on with the article, and there's copies of the article that are available on the front table here, and that's what we're going to try and talk about tonight. We're going to be collecting ideas on what climate competent lawyering means, and we're among the panelists and hopefully afterwards with you all as part of a broader conversation. To facilitate that, Sam Carvalho is here. Sam's over there actually back, and he's an LLM student from Brazil, where he practices as a tax lawyer. He's presently doing an LLM specialization at Pace. By the way, does anybody know where that noise is coming from?
Yes. Yeah, I think it's from the Zoom. Maybe the person who's on the screen.
Okay.
The zooming person.
If you're on the screen, if you zoomed in, why don't you consider muting? Because we're hearing something. Anyway, that's the article. Irma Russell and Matt Bogosian and I wrote the article, and we focus on the duty of competence. Again, if there's somebody, is everybody muted on screen? Don't know where that noise is coming from. All right. Anyway, Sam's going to be collecting those ideas and taking notes. We're also recording this program.
Speak into the mic.
Sorry?
Speak into the mic.
Can you all hear me better now?
Yes. Much better.
All right, sorry. I'm not going to start over. As you can see, we have a lot of speakers. We've got 4 on Zoom, and you can see the panel here. Each speaker is going to get about 3 to 5 minutes. I'm going to ask a question of each speaker, and that person will answer it. And our goal is to figure out what the professional responsibility of lawyers means to address climate change on a very practical, day-to-day kind of basis, and to focus on specific things that lawyers can and should do and why. This is a 90-minute event, and I'm hoping that we're going to have 30 minutes for Q&A at the end. So given the number of speakers, we're going to try and run this as smoothly as we can. So to start with, I'm going to ask Amy Edwards a question. Amy is a partner at, one more thing I want to do before we start is to give everybody a chance to introduce themselves in a sentence or two. And Yvonne, why don't we start with you down at the end, and then we'll go across, and then we'll have our Zoom speakers introduce themselves. Just a sentence or two, so you get an idea. So you get an idea of who all is here.
Sure, absolutely. Thank you, John. Can everyone hear me? Good evening, everyone. It's a pleasure to be here. My name is Yvonne Norman, and I am the chair of the Environmental Justice and Environmental Rights Subcommittee here at the New York City Bar Association. And I am also the co-chair of the Environmental Justice Committee at the New York State Bar Association.
Hi, everyone. My name is Camila Bustos. I use she, her pronouns. I'm an assistant professor of law at the Elizabeth Hobbs School of Law at Pace University. I work at the intersection of climate migration, climate ethics, and the law. I'm also a co-founder of Law Students for Climate Accountability.
Good evening, everyone. I am Amy Edwards. I'm a partner with Holland & Knight in Washington, D.C. I'm a past chair of the ABA section of Environment, Energy, and Resources. Very pleased to be back with you here this year.
Thanks, Amy. Hi, everyone. I'm Georgina Beasley, and I lead the Secretariat at the Net Zero Lawyers Alliance. We're an alliance to mobilise commercial lawyers, law firms, and ultimately the law to accelerate the transition to net zero.
Good evening, everybody. I'm Marcy Kahn. I'm a former New York State trial and appellate judge, now retired. In retirement, I do some climate change mitigation work, which I'm going to tell you more about in a little bit. And I also do some rule of law work here at the New York City Bar Association.
Hello, I'm Nina Pindham, a barrister in private practice at Cornerstone Barristers in England. I am also vice chair of the UK Environmental Law Association, and most importantly for today's purposes, a member of the Bar Council of England and Wales's Climate Crisis Working Group. Thank you.
Irma, you want to introduce yourself?
Did we lose her?
Did we lose her?
She's on Zoom, right?
Yeah, our Zoom folks, do you want to introduce yourselves? Did we lose them?
I think we may have. I'll see them in email.
All right, well, we'll let them introduce themselves when they start speaking. Hopefully we'll solve this. So we'll start with Amy Edwards. Amy led the ABA effort to adopt a resolution in 2019 on climate change. And Amy, could you please explain what that resolution urges lawyers to do and why, and what practical steps lawyers should take in their legal work to do that?
Certainly. This was not the first climate resolution that the ABA had passed, but it had been more than 10 years since the ABA had a resolution on climate change. And at that time, the U.S. was considering cap and trade. And we felt it was timely and appropriate. This is in the middle of the Trump administration, that lawyers should be doing more to combat climate change. So our resolution had 4 basic points. It urges all levels of government and the private sector to recognize their obligations to address climate change and to take action to reduce greenhouse gas emissions to net zero or below. Secondly, it urged Congress to adopt legislation using a broad range of legal mechanisms, including market-based mechanisms, to ensure a just transition and to use sustainable development principles. Third, it urged the United States to remain engaged in international discussions and to negotiate treaties and other agreements. And finally, it urged lawyers to engage in pro bono activities and to advise their clients about the risks and opportunities associated with climate change.
So thank you, Amy. One thing we should add, and Amy, you can maybe address this, is the ABA passed a resolution in August on sustainable development. You want to add anything on that?
Again, the ABA has been a leader on sustainable development issues for a very long time. It first adopted a resolution in, I believe it was 2001. The last resolution, I believe, was in 2013 before the one that was adopted this summer. And so obviously a lot has happened in the sustainable development field, such as the 2015 principles for the UN. So this one really updated that prior resolution and again urged lawyers to advise their clients about the risks and opportunities associated with sustainable development.
That's great. And so what you can see is the American Bar Association starts out with pretty good position on saying lawyers ought to do this. And again, what tonight we're going to try and do is dig into the sort of the professional responsibility aspect of that. And to kick that off, I'm hoping we have solved the Zoom problem. Irma Russell, are you there?
They can see us but not hear us.
Sorry?
They can see us but not hear us, apparently.
I'm technical folks, I'm hearing that they can see us, but they can't hear us. Can you hear us now? Sorry, Julie? Okay. Well, I tell you what let's do is while we're solving that, let me just say in a couple of sentences.
Can you hear me now?
Okay, now we're really back. Irma, are you there?
Two eyes.
Irma, can you hear us? Irma, I can see you, but I think I can see you, but I can't hear you. Can anybody else on Zoom hear us? Can anybody on Zoom hear us?
No, John.
All right, so what the article does is it traces the history of competence, the lawyer's duty of competence, and describes the many ways in which that duty has changed, not because the requirement for competence has changed, but because the things that need to be done to be a competent lawyer change. And then the article describes across a wide range of legal practice areas how climate change is affecting the practice of law and how it's becoming increasingly difficult to practice law without knowing something about climate change. And finally, it suggests some principles for climate competent lawyering. The next two speakers I was going to ask are also on Zoom, but I'm gathering Alasdair and Letitia, are you? All right, well, this may be fewer panelists than I thought. Nina, you are here. Barristers in the UK have set up their own legal organization, the Bar Council of England and Wales. So what special professional responsibilities do barristers have regarding climate change? And what is the Bar Council considering to address those responsibilities?
Well, hopefully, fingers crossed, we'll get Alasdair Cameron, who's from the Law Society, on board, because he's really leading, I think I can say this globally, the work on actual regulation and issuing of guidance on the members of the legal profession in England and Wales and some other countries in Europe. We've got a split profession between barristers and solicitors. So Alasdair is the solicitor side, and so I'll be discussing the barrister side. We've got differing professional obligations. Solicitors in England, and that's where my home jurisdiction, that's what I can talk about. They are able to pick and choose their clients. Barristers are not. We are subject to what's called the cab rank rule, which I've been told by many taxi drivers is absolute fiction, but the barristers at least adhere to it. It's the core of our practice, and it's the rule that where a client comes to our clerks with a case for whom we are professionally qualified to advise on and act for, we take that case. Our personal views, our ability to pick and choose our clients, completely irrelevant. We cannot pick and choose our clients. So that puts us in a very special position compared to solicitors in England and Wales, as well as I understand it, North American qualified lawyers. So the Bar Council is currently working on guidance for barristers. It is not published yet, so I have to say at the very beginning, this big caveat, nothing I say should be taken as an indication of the form or content of that guidance. So I can speak about it in general terms, but I don't want to use up all of the time. Hopefully we can get the rest of the speakers here. So I'll stop there and then get into it in more detail as we discuss further what the actual content of this forthcoming guidance and regulation on lawyers will look like.
All right, well, thank you. So, Yvonne Norman, what do you see as the fundamental ways in which lawyers can fulfill their duties of competence to address climate change?
Sure. Thank you, John. Our professional duty of competence in the context of climate action includes efforts to motivate and influence others to take action. There are three fundamental ways in which we can fulfill that duty of competence. That is leadership, education, and staying informed. And let me just spend a little bit in each of these areas. As far as leadership, we all have the potential to be a leader at any stage in our careers. If we have the passion, others will follow. One effective way to do this is to join bar associations, and not only join the associations, but become active members and volunteer to lead committees and subcommittees. That active participation allows attorneys the opportunity to learn from experts and professionals and to share fresh perspectives to influence teams to take climate action. For instance, this event. This is a clear example of the leadership efforts by our Environmental Law Committee in highlighting the importance of becoming climate competent attorneys. Another example of leadership I can share is a law school outreach that I've been participating with the New York State Bar Association. And the purpose of that initiative is to bring awareness to law students and stress the need for their talent and their climate competence to tackle the current complex environmental challenges. As far as education, I firmly believe that educating others leads to impactful change. If we as attorneys share our knowledge with others, colleagues, law students, advocates, significant change will follow. You can organize workshops, speaking engagements in your bar association committees, or you can write articles on relevant climate action topics. Our committee earlier this year collaborated with the New York State Bar Association and other sponsors on putting on an educational webinar to assist municipalities understand how they could optimize their efforts and capacity to access federal funding under the Inflation Reduction Act, or IRA. The specific focus was the CPRG, or Climate Pollution Reduction Grant Program, which has approximately $4.3 billion in federal funding for greenhouse gas reduction projects. We had over 100 attendees. It was very well received, and there's been talks of doing maybe a part 2 because federal funding continues to evolve. Another way is to formally teach others, meaning joining a law school, and even on a part-time basis. It's an option that you can always explore. Another team that I'm working on with, we are proposing a new class on climate-driven disaster law. We're proposing this new class because we believe that law students must be competent in disaster response law. So the message here also is, if you want to teach a climate-related topic that is not in a curriculum, you can always propose it and make it happen. And lastly, staying informed. All attorneys are required to stay up to date on new policy, changes to legislation, and developments in litigation, which might affect our collective efforts to achieve a sustainable future, including other jurisdictions. One notable example is the recently passed Vermont's Climate Act, which was enacted on May 30th of this year after the catastrophic flooding in the summer of 2023. There is a similar bill in New York State, the Climate Change Superfund Act, which passed the Senate and Assembly and is awaiting governor's signature. Among other things, this act will establish an adaptation cost recovery program and a climate change adaptation fund. It is also very crucial to stay informed on nationwide and global climate accountability litigation. Landmark cases such as Held versus Montana or Navahini versus Hawaii Department of Transportation are examples of significant litigation that all climate competent attorneys must be very familiar with. And on this point, I highly recommend relying on resources and databases that are indispensable sources of up-to-date information in this area. And again, these are just a few examples of practical ways in which we, as attorneys, can all meet our duty of professional duty of competence. Thank you.
Well, thank you. So, Camila, you have some interesting history, which you referred to. You were with, as a law student, you were with climate law students for climate accountability. How many of you folks know about law students for climate accountability? How many of you have heard about? Okay, so they do a scorecard every year. They take the top 100 law firms and they grade them, which is kind of a gutsy thing for law students to do. And they have a really, really tough curve. Like I think maybe 15 out of 100 get a C or better. I think it's something like that. Okay. And you've got a forthcoming article now, which you told me you changed the title of. Listen carefully to the words, representing climate wreckers. Okay. So what specific things, based on that article and your own thoughts, do you think lawyers are obliged to do?
Thank you, John, for the invitation and for the honor to be here with folks who are really leading on this question of climate and our professional role and duties. So yes, my academic work really started when I was a student, actually, and I thought I was going to be a climate lawyer. And so with some colleagues, we founded this organization and produced a scorecard. I'm now sitting on the board of LSCA, Law Students for Climate Accountability. But my academic work has really looked at the intersection of climate change and legal ethics. And this piece, representing climate records, forthcoming at the NYU Environmental Law Journal, looks at basically the question of who deserves representation. One of the things we kept encountering when we tried to raise awareness about the scorecard was this idea that even fossil fuel companies deserve representation. So this is a really interesting ethical and philosophical question. And that led me to a rabbit hole of research into looking at the origins of that idea. Where does this idea come from? Obviously, it's very different to invoke the right to counsel and access to justice in the criminal context by a criminal defendant than a corporate actor in a civil context. So I start teasing out some of these questions in this article that I'm happy to share if anyone is interested. I basically have three main claims in the article. The first one is I posit that lawyers shouldn't be taking any new fossil fuel clients. The science is clear. We have a consensus around fossil fuels is staying on the ground, and any new fossil fuel production is going to drive us into climate chaos and beyond the scientific consensus we've adopted. So I believe firms should have a red line of no new fossil fuel representation. For those firms with existing clients and existing retainers of that sort, of course, there are duties to be competent, to continue to advocate for your client's interests. But I believe it is in our duty to actually start transitioning that representation and guiding clients to move away from carbon-intensive industries. We need competent lawyers at law firms doing this work. So I'm not saying that tomorrow my dream would be for everyone to drop their fossil fuel clients. That's neither realistic nor actually sound practice. But I think internally firms need to start having really hard conversations. We're always told that lawyers can't decide who their clients are, and of course in the UK it's a bit different, given the cab rank rule. But here in the US, there's no such thing as an obligation to represent any client. We don't have that. And we've seen, firms drop clients historically. We saw firms drop tobacco. We saw them drop, gun manufacturers. More recently, after the Russian invasion of Ukraine, there was a rush of law firms dropping Russian oligarch clients. So this notion that firms can do this is, I think, historically inaccurate and just another way to evade accountability. The third thing is really looking into greenwashing. And I think the Law Society, and I hope Alasdair can join us, has issued some excellent guidance on what firms need to be looking related to greenwashing. If a corporate actor is using PR efforts to greenwash their image, they may face some sort of potential sanction or procedural grievance through state bar associations and the like. I think here we have a responsibility to, a duty to candor and, again, competence, encompassing this idea that we shouldn't allow our clients to greenwash their operations. And the fourth one really is what folks in this panel have done, right, which is really take a leadership effort among bar associations to issue guidance, directions, examples of what lawyers can and should be doing. And again, that'll depend a lot on if you have a solo practice or you operate as an associate at a big law firm. But again, there's lots that can be done. And my contribution here tends to be more academic, at least as it stands, based on legal ethics principles.
All right. Well, thank you. So, Georgina, you represent an organization that has 35 member firms and more than 100,000 lawyers. That's pretty impressive. And across 40 different jurisdictions, so it's all around the world. So how does your organization see the professional responsibility of lawyers to address climate change? And what practical steps should lawyers take?
Yeah, thanks so much, John. And I'm going to get to the answer in a bit of a roundabout way. So just to start with a bit of context, maybe TMI, but I'm expecting a baby in a few weeks, actually. And unfortunately, what we can all expect is at current rates of warming, by the time my child is around 45, there will have been a 50% destruction in GDP. So if you take a moment to think what sort of events would lead up to that kind of decline and the events that would follow, it's a pretty concerning, terrifying picture. But fortunately, we do know what we can do about it, and that is meet the goals of the Paris Agreement. Maybe easier said than done, but to do that, we need to see this phasing out of high emitting activities, and on the flip side, the scaling up of the low emitting activities so that everyone's got something to transition to. So what has this all got to do with our professional responsibilities? The scientific and economic analysis is clear that climate change is a systemic risk, it's an existential threat, and it's a commercial reality for law firms and their clients. So if you're a lawyer and you're not understanding climate change, you're not understanding transition, that's indicating a lack of competence, and it's indicating that opportunities will be missed and risks will be realised. So really, what clients need are lawyers to be able to guide them through this net zero landscape, which is complex and it is messy. And we all need, clients or not, we need our lawyers to be creating the enabling environment for transition to occur, and for lawyers to be finding the legal solutions to some of the really sticky issues in transition. So I guess all in all, being able to advise on transition as a lawyer is the right thing to do. It's the necessary thing to do. It's the smart thing to do. In terms of practical steps, going to do a bit of a shameless plug, but the NZLA, we have some resources that I think are really, really helpful. We've got a transition framework for commercial law firms, which looks at how law firms can transition to true net zero. So beyond your operational emissions, right into, again, those really sticky bits. And we developed this in close sort of contact with the transition, the TPT, the Transition Plan Task Force, based out of the UK, and it is in line with their sectoral guidance, so it looks at ambition, action and accountability. Another resource, if you're struggling to see what the connection is between climate change and your practice area, if it's not so apparent, we've got the US Climate Atlas, and we've got the project manager in the audience, Hannah White, who did the most impressive job at coordinating efforts to map out different areas of the law and look at how climate change is impacting those areas and how, as a lawyer, you can have an impact on transition. So questions to Hannah afterwards. So those would be my start for 10 for some helpful resources. Thanks, John.
Well, thank you. So I'm looking at, I put my email on airplane mode so I wouldn't be distracted by my brother calling me. And of course, that means I missed all the emails back and forth about the tech problems. And so what I'm hearing is an email from somebody who they tried dialing in, but there's still no audio on the dial-in. Is that, and I don't know whether that's it's still true. Okay, so we are with a smaller panel than I anticipated, which is good news, I think, because until we get this fixed, there'll be more time to talk to you all. I asked Marcy Khan to participate in this because Marcy Khan's been a judge. She's been sort of outside climate world, but she's a long time judge. Okay, recently retired. You heard that. And those of us who've been around the block more than once know that competence issues come up in areas other than climate change, if you know what I mean. They come up everywhere and all the time. And so, as a longtime judge, you saw these issues in all sorts of contexts. And so, in light of that, what should lawyers pay attention to concerning climate change?
John, thank you for inviting me to participate here. I'm going to speak from a practical point of view, looking at the role of the lawyer in the courtroom, before the judge, in litigation. not from an academic point of view, but to me, there are four things that lawyers need to keep in mind when they appear in court. First, the judge, and very likely some members of the jury, will have been trained and educated on the effects of climate change and possibly on approaches to mitigating it. For example, the Environmental Law Institute has been training judges on climate science for years now, and I believe some other organizations have as well, judges around the country, federal and state courts. So you're going to walk into an environment where the people you're trying to impress know quite a lot. Second, to the extent you appear to be uninformed or misinformed about climate change, your credibility is going to suffer. And I just want to say, from my experience, jurors are smart and judges are smarter than you might think. And if you assume otherwise, you're not going to be helping your client. Third, if you do not approach the legal and factual issues in your case with a knowledge of climate change science and development in the law respecting climate mitigation and adaptation, and understanding the law that pertains to it, including mitigation obligations of those in your client's position, and that's true whether the case sounds in real estate and construction, energy, transportation, finance, insurance, bankruptcy, securities, torts, shipping, agriculture, internal corporate investigations, or any other areas, all of those tracked apparently by Hannah for you, you will probably not be providing the best representation to your client. Fourth, understand that the law is going to be changing. The judge will be invited to move the law forward to deal with the climate change crisis. And you can help tell the judge how to do that and affect the transitions that you just heard Georgina talk about. Or you can be left behind. Basic principles of tort and contract law are evolving now, including as to foreseeability. No longer can a lawyer take refuge in being neutral about the climate, nor in not being an environmental or energy attorney. So why does this matter? Well, even if your adversary does not seek sanctions against you in the litigation and does not file a disciplinary complaint about you, and even if your disappointed client does not sue you for malpractice, lawyers from time to time do seek personal recommendations from judges for whom they have tried cases. And if you have not presented as competently knowledgeable, you will not receive the commendation you are seeking. Applying to new employers, seeking renewal of your status as a public defender, seeking to become a judge yourself, there are all sorts of situations in which you might want to have a judge who's familiar with your work be a reference for you. So, what can lawyers do? Well, the good news is that there are ways for you to solve this problem. You heard Yvonne mention some of them already, and I'm going to mention one to you right now. Since my retirement, I have had the privilege to be a part of the Legal Pathways to Deep Decarbonization Model Laws project, which is a pro bono endeavor based on the 2019 book edited by Professor John Dernbach and Professor Michael Gerard. Maybe we could go to my slide, please.
I'm trying to get the slide. Can you Um, there we go.
There we are. Okay. So this book that came out in 2019 contains 1,500 recommendations for legislation that would mitigate climate change by reducing greenhouse gas emissions in ways that make systemic change, through which we could reach an 80% reduction in greenhouse gas emissions by 2050. It's on a parallel track, really, with efforts in the UK that deal with contract law provisions. Our project here in the U.S., which has been emulated in Brazil and in Australia, has recruited scores of lawyers from dozens of law firms to work pro bono to draft these model laws, and we have paired each drafting team with peer reviewers who have expertise in the relevant area, whether it's buildings, utilities, automobiles, financing, shipping, forestry, or anything else. And we have, to date, produced more than 80 model laws, which are now published on our website. And you can see the link to our website on the screen there. We also consult with NGOs and policymakers on legislative strategy and helping to educate them on what they might do to improve the situation in their particular jurisdiction. Our website, by the way, is a great source for research by policymakers, and we have a database of more than 2,000 laws that have already been enacted in federal, state, and other jurisdictions, and you can check it out and educate yourself in these areas. So we would like to invite you to join our ranks. This is really a project of Professor Dernbach's. He was the one of the two visionary leaders that gave birth to it. And one of my colleagues who is really our leader on the ground, Professor Richard Horsch, is here tonight too. And we would be glad to talk to you about any questions you have. My contact information is sort of on the screen. Okay, marcy.kahn@lpdd.org, marcy.kahn@lpdd.org. Feel free to reach out to us or talk to us in the Q&A or after the program this evening. The lawyers who have worked for us have found it wonderfully illuminating, and as they've researched and looked into an area about which they did not know much before taking the project on, they got to work with a peer reviewer who was an expert in the field, and they have learned a great deal and found it very satisfying. Thank you.
Well, thank you. Thank you so much, Marcy. That's such an interesting perspective. I'm checking my email again, and it looks like we're not going to get our remote speakers at all tonight. So we're going to do a little bit of improv here. I do watch improv occasionally when I'm in New York. So what I think I'm going to ask Amy to do, is there anything in terms of counseling clients with regarding climate change that you would add to what you've heard?
I think that all of us need to be aware that the law is constantly changing. And I know that a lot of our clients don't necessarily want to hear about these changes, but as John knows, a lot of the standards that have been voluntary around the world are quickly becoming mandatory. And we don't want to have our clients be blindsided by these developments. So it's really important for us as lawyers to be aware of these evolving standards. I was in a number of sessions today where they're talking about ISO taking more of a lead to harmonize the various alphabet standards that are out there, which is part of the reason it's so complicated for us to guide our clients in the direction in which this is moving, but it's moving in that direction. And we do need to advise our clients about the risks and the opportunities. And there are both out there available for them. And it gets back to the fundamental issue of competency. We have a duty to reasonably advise our clients and to be up to speed on these changing developments. So whether this is something that your clients are presenting to you on a daily basis or not, you really need to understand what is happening out in the bigger picture.
Well, thank you. That's a good overview. I'm reminded, as you recall, back when we began this, we had all this hope we would have all these speakers, and we're not getting them. And so what Nina did in her presentation, she shortened her presentation. And what I'd like to do is cycle back to what the Bar Council is up to in the UK, and then if you like, maybe tell us a little bit about what the Law Society did.
Oh, I wish we had Alasdair,
I know,
but he's
we'll
been name checked enough. I think we've anyway. Next year, all right. I think there's quite a lot of consistent themes between everything we've heard from all the speakers and what we're doing at the Bar in England and Wales, following on from the leading work of the Law Society. We're also quite proud of our 2008 Climate Change Act. I was involved in several successful judicial reviews of that, so we can discuss actually litigating climate law if you want. But I want to talk about the professional duties that we're subject to, because that's impacting every lawyer. So the three key themes I'm seeing are the difference, the nature and the impact of the climate crisis is having on the legal profession and our clients. That's causing a need for a specific response. Secondly, the duty of care owed by lawyers both to our clients and to the court. And thirdly, the increasing risk of legal action. Lawyers are always worried about litigation against who are seen as the facilitators of climate breakdown, i.e. professionals who are advising climates carrying out climate damaging activities. On the first of those, I don't need to tell this room, the climate crisis is an existential threat. That is now something we are seeing in judicial advisory opinions. Judgments around the world are now picking that up. And you're a knowledgeable audience, you get it. Secondly, this theme that we've heard from every speaker about the duty that we owe both to our clients to be competent in our advice and also importantly to the court. And I'm sure you have a similar obligation here as litigators not to mislead the court. And that includes misleading them by being recklessly indifferent to what's true. And in our view, that includes a lack of knowledge or presenting a case on climate that is contrary to well-known facts. And more, we are seeing the established opinion being that set out in the IPCC reports. That is being relied on by judges and arguably is now establishing itself as a standard of knowledge. Obviously, there are thousands of pages. We aren't expecting every lawyer to understand that, but they are increasingly being judged by a reasonable practitioner's standpoint, which includes some knowledge of climate change. And I would argue, along with Amy and some of the other panelists, that a reasonably competent barrister is aware of the impact of at least the relevance of climate change to their practice area and not to advise their clients accordingly. And similarly, the court, what Marcy was saying, probably Judge Con, I feel very deferential to you. It's very reassuring to hear that judges care that we are competent. Yeah. I don't want to disparage colleagues, but you wonder. The short point here is that barristers should ensure they're familiar with the facts relating to climate change so far as they're relevant to their particular case. We all know, those of us who are litigators, judges ask an awful lot of questions. We welcome that, of course. But we are there to help advise the judges on what's true and relevant facts about the case. And a lot of the climate law cases that I'm involved with, judges are asking quite detailed questions about not only the law, but what science underpins the law. It's not their forte, it's not their area, it's not something we're asking them to reach a judgment on, but it is relevant. And so lawyers again have to bring themselves up to speed on that. Thirdly and finally, growing awareness of the responsibility of professionals in sectors which arguably enable climate damaging activities. Accountants are onto this, so they're developing professional standards across the board. And as we've seen from this panel, lawyers are now getting up to speed. So I'm going to end on one thing. Anybody who's ever heard me talk will have heard me say this. Lawyers are the economy's janitors, and I can do no better than Professor Atkin and Mildenberger's landmark description in there of what is facing the economy in due course. This is their Prisoners of the Wrong Dilemma paper published 2020. They said climate policy involves a dramatic renegotiation of the institutions that structure economic and social activity within each economy. So there's going to be a huge amount of work for economic janitors to do in the years to come. It is a business opportunity, but more importantly, it is our duty to our clients and the courts in which we represent our clients to do our best for them, and that includes knowledge of climate change.
Well, thank you. That's very helpful. The economy's janitors. I like that. I had not heard that before. I've heard so many things.
I always thought that the judges were the janitors. I guess you're not that different from us in that, the cases come into our courtroom. We don't get to choose them, just as you as a solicitor, as a barrister, don't get to choose your cases. But we have to fix it.
Generally, they don't come to court unless they're very, very messy. So I think you might be right. Yes.
Well, so before I would like to ask one other question related to the issue that Marcy talked about, which was what resources are available to lawyers who want to do this kind of work. And you heard Marcy describe the Legal Pathways Project in very, very generous and kind terms. But there was something else she alluded to, and we've got a leader in that effort in the back room. And again, this is improv night, okay? So Ben Metz is with the Chancery Lane Project in the UK. And what the Chancery Lane Project does is bring together lots of different people to draft model contract language for supply chains and for other things. And so if you want, for example, to go zero carbon in your client wants you to figure out how to go zero carbon in a particular way, and you have to push that down into the supply chain. The Chancery Lane Project may have just the contract clauses for you. And Ben, if you've got a minute, if you want to take a minute to explain a little bit about what you do, I think we can get a microphone in your direction.
Or I can just shout. Thank you. Hello, Georgina. We met never in real life. And you had to come all the way across the Atlantic to actually meet when we're just down the road. So I'm Ben Metz. I'm the exec director of the Chancery Lane Project. It's a rather anachronistic name that refers to the home of common law in England and Wales as it was originally born. If it was in India, it would be the Talit Row Project. And I think we need a bit of a rebrand. But essentially, we, in part inspired by LPDD, we, at the beginning of, actually before lockdown, but really harnessed by COVID and the furloughing of the global legal profession, we generated a huge amount of content related to contractual clauses aimed at decarbonising, aligning with biodiversity, and to some degree looking at just transition considerations in contract law. We started off as a small pro bono outfit where we spent in the first year £833 on train tickets. This morning I welcomed our 25th member of staff. We're in 110 countries with 37 working groups active in different countries. And early results on our 2024 impact survey indicates we are having a direct impact on billions of dollars of contract value, aligning that contract, that economic activity from very small contracts of tens of thousands of dollars up through 25, 50 million contracts in all shapes and sizes of organizations across the world. So hopefully there aren't any funders in the room, or if there are, listen up. We're in the billions, and we're trying to figure out how to move to the trillions. So if you want to engage with, actually, here's a brilliant plug for you and for me, Camilla, and we've never met, have we? If you want to think about how your day-to-day, week-to-week practice as a lawyer, moving contracts from one side of your desk to the other every day, can change and align with climate, then come and have a chat. I'm actually presenting at the Offit Kerman offices. I don't know the exact address, but I can let you know after this, 9 a.m. tomorrow morning. And my highlight of my tomorrow is 3 p.m. on the corner of 6th and 42nd. Is it? Law Students for Climate Accountability are doing a walking tour, 6 on 6th. So I'm really looking forward to meeting the Law Students for Climate Accountability folk on the ground. I hope that's all right. Great.
Terrific. Thank you. That concludes the first part of the discussion that occurred on September 23rd, 2024. We now turn to each of the four speakers who are unable to join us then, who will each make separate presentations on the professional duty of lawyers in action on climate change. Thank you.
Good evening. My name's Emily Morrison, and I'm a project lawyer at the International Bar Association's Legal Policy and Research Unit, where I lead on matters of climate change and business human rights, how these intersect with the legal profession, and how the legal profession should be responding. I'm very grateful for the opportunity to provide some comments on what I see as the IBA's role in helping bar associations around the world to address the professional responsibility of lawyers on climate change. The IBA is a membership organisation of around 80,000 individual international lawyers from across the world and almost 200 bar associations and law societies from across 170 countries. 4 years ago, the IBA published a climate crisis statement, setting out its position as to the role of the legal profession in responding to climate change and the actions that it recommended that both lawyers and their bar associations should consider. The statement explicitly recognises the role that bar associations and similar bodies have in supporting their members to respond to the climate crisis. It recommends that bars consider actions including engaging with law students and law schools on education on the legal elements of climate change and how climate change is linked with human rights impacts, developing practical educational tools for qualified lawyers, and establishing specialised climate change committees within their organisations. It also encourages bars to call upon the lawyers and legal practices in their respective jurisdictions to share the actions that they are taking to address climate change, so that these can be used by organisations to help develop best practice guidelines for others in the jurisdiction. The IBA statement catalysed climate statements from other bar associations across the globe. And earlier this year, the IBA launched what's called the IBA Climate Registry to provide a public knowledge sharing platform for bars to upload their climate initiatives. So far, this registry has received contributions from bar associations and law societies from jurisdictions spanning Europe, Asia, North and South America and beyond, on initiatives including organisation-wide climate declarations and policies, guidance and educational materials for their members on how climate is relevant to their legal practice and legal professional duties, including the duty of competence, carbon footprint reports from bar associations who have taken the initiative to measure their Scope 1, 2 and 3 operational emissions, submissions to public consultation on climate legislation drafting and review processes, and also terms of reference for specialist climate change committees that bars have established for the purposes of increasing the climate literacy within their legal community. My team is now supporting the preparation of a report on the various approaches that bars are taking to addressing climate change, including the challenges that they face in this work and how these are being overcome. Further, as an observer organisation to the United Nations Framework Convention on Climate Change, the IBA convenes events at UNFCCC conferences in collaborations with other bar associations, law firms and civil society to help elevate the role of the legal profession in responding to climate change. So against all of this background, I see the IBA's role in helping bar associations to address the professional responsibility of lawyers on climate change as principally one of knowledge sharing of good practice and helping bring together bars from across jurisdictions to share the work that they are doing to educate and support their members when advising on climate change. I'd also like to highlight that the IBA plays an important role in helping lawyers and bar associations to appreciate the critical links between business human rights issues and climate change considerations. In 2023, the IBA issued updated guidance on business and human rights for lawyers, which recognises that climate change can have severe human rights impacts and that businesses contribute to climate change and that this is deeply relevant to legal practice across a range of practice areas. Further, just last month, the IBA issued updated 2024 guidance on business human rights for bar associations. This guidance provides a roadmap of what bar associations can do to help their members understand and apply the United Nations guiding principles in the course of their legal practice. Relevantly, it provides bar associations with suggestions for how they can address business human rights issues, such as climate change, through guidance and education. To finish, on a personal note, I'd like to highlight that climate change is the most urgent crisis that our society faces. It is complex and deeply linked with human rights and other global crises, including pollution and biodiversity loss. Every decision that we make in our personal and professional lives has potential to improve or to worsen these linked challenges. I watched a recent lecture where Professor of Law and Professional Ethics at University College London, Stephen Vaughan, asked his audience, when at the end of your life you tell the story of your time as a lawyer and the choices that you made, what will you be able to say about how you helped to worsen or lessen the climate crisis? I firmly believe that bar associations can play an instrumental role in helping lawyers answer with the latter, and I look forward to continuing with this work through my role at the IBA. Thank you.
Hello, everyone. I'm glad that you were able to attend the New York Bar Association program on competence in a climate imperiled world, or competence and climate change. And my name is Irma Russell. I'm Professor Emerita very recently at University of Missouri, Kansas City. And my part in this program is to give you the basics. And to do that, I want to tell you what competence is. You know already, of course. And I've done my job if throughout this presentation you might be muttering either in your brain or out loud. Of course, of course, of course. This is a no-brainer. And it really is. It's just that putting together these basics sometimes results in new insights. So the structure, I'll talk about the structure, the meaning of competence, and results of failing the duty of incompetence. And finally, the importance of this duty in the world of climate change. So, as is the case with law in general, the law governing lawyers, discipline has multiple aspects. It runs on a totality of circumstances. So if the law changes, of course, that imposition of law on you and your client makes a difference. And also, we don't need to change the duty of competence. We don't need to redraft or do any kind of proposed rule on this because the very general, some would say vague, duty itself allows for change inside that definition. The articulation of that duty is doing what reasonably should be done. It is intentionally vague. It is not a blunder, but that's what gives it its sort of ubiquitous and flexible character. Now, all professions have this duty of competence, doing what you should do. And in fact, trades as well as professions have it. It's ubiquitous. It's stated as the first rule of the model rules of professional conduct. Every state has adopted it as drafted by the ABA, and it requires lawyers to comply with obligations as stated in the rules themselves and by their duties under the jurisdiction of licensure. In other words, the law. Not only does it require the basic skill and knowledge necessary to advise clients, but it also includes the duty to update, to keep abreast of changes in the law. So it's evolving. That's not, of course, unique. Again, of course, it's like all law. All law is evolving in reaction to circumstances. And one big circumstance, of course, is climate change. We don't need legislation, really, for this evolution. What we need to show if someone is challenging a lawyer's actions is how the actions comport with that total duty of doing what reasonably should be done. Now, many lawyers would do more than the basic duty of competence. And the fight there, of course, is, well, does the fact that a lawyer has done more, has been able to advise clients before the law changes, say, for example, the law of Superfund, save the client money by advising the client early on the coming change? Does that then make that sort of excellence imposed on everyone? The answer, of course, is no. This is a baseline, general, basic duty. But at some point, everyone recognizes the duty to know about metadata, for example, or advise always for a phase one in the environmental field before your client purchases property, unless circumstances make it unnecessary to have the phase one. So it's evolving at the point where everyone says, of course, everyone in the chair of responsibility to judge the lawyer, at that point, then the duty of competence will be judged. It sounds vague. That can be annoying when you are the person who needs to comply. That, of course, is the way our clients feel as well, facing common law duties. So our duty is to do what reasonably should be done in helping them know what they reasonably need to do under both the law and the common law. It is not necessarily easy, but it's the basics, and it's the basics of law, medicine, and really every profession, every field. So I hope that this gets us off to a good start, and I welcome your questions. I'll stop there.
Hello, everyone. Thank you so much for having me today here to talk about such an important topic. My name is Letícia Campos Melo. I am a dual qualified solicitor in Brazil, in England, and Wales, and I am the Secretary General of the Foreign Affairs Committee of OAB, the Brazilian National Bar Association. The Brazilian Bar Association has as members 1.4 million lawyers in Brazil. To practice law in Brazil, you must be a member of OAB. OAB is also the regulator of the profession, the legal profession in Brazil. And according to the Brazilian Constitution, we have prerogatives to defend democracy, the rule of law, and the human rights. And specifically in respect to human rights, the Brazilian Supreme Court has recognized the Paris Agreement as a human rights treaty, what puts climate very much inside of OAB mission. And that's why over 1 year ago, in April 2023, we have issued a recommendation to all of our 1.4 million lawyers, addressing pretty much 3 pillars in respect to climate change. The first one, it's more towards all our OAB chapters, which are 27 in each one of the states in Brazil and the capital, Brasilia. And we tell our chapters to engage actively in participating in the drafting of legal recommendations and laws and regulations in respect to climate change. Also, to challenge laws or regulations that may negatively affect the efforts towards defending climate. The second one is towards the professionals, the lawyers themselves, the duty to point out to clients risks that they foreseen of the activities that can negatively impact climate. And the third one, to law firms, to achieve carbon neutrality, reviewing their practices. We are also very much engaged in capacity building of all our members, participating in international events, exchanging information and good practice with other bar associations, as we are doing today, and actively being a very important presence at COP's, Conference of Climate. We believe that today, being a competent lawyer means not just addressing the black letter law, but also foreseeing risks for our clients in respect to climate change and trends of responsibilities and risks. And this demands more and more collaborations between international lawyers, different jurisdictions, and also between bar associations, which it's great what we are doing here today. In conclusion, as lawyers, we are uniquely positioned to guide the legal framework towards sustainability in court and in consultancy matters. And as a bar associations and regulators of the legal profession, we have a duty towards society. Thank you so much for your time and for giving me this opportunity.
Well, thank you to the New York Bar for letting me provide my remarks here. I really appreciate the time that has been given to this discussion, and indeed to the Law Society of England and Wales to discuss what we've been doing on producing guidance for lawyers on how climate change impacts their practice. Now, the Law Society, much like the American Bar Association, took heed of the resolution which was published by the International Bar Association in 2019 on how climate change is impacting both solicitors, law firms, and bar associations. And we issued a climate change resolution, which has similarities both to the IBA's climate change resolution and indeed the American Bar Association's resolutions as well on the matter. The way which we saw most effective to address our members and recognizing their needs, but also our role as a professional membership body and not a regulator, was to produce guidance on how climate change was impacting solicitors' professional duties, recognizing that climate change is intersecting in all areas of the law, and to perform an exercise of examining each and every single area of law and providing bespoke, detailed advice would be, a gargantuan task. But instead addressing the profession as a whole, albeit at a high level, to help them understand and apply that critical thinking as to how climate change impacts your client advice, we thought was imperative. So we published a piece of climate change guidance in just before COP27 sorry, not COP27, just post COP27 in April 2023, which addresses law firms and lawyers respectively. Part A looks at law firms and what they should be doing in the context of climate change. So that ranges from the relatively mundane issue of operational emissions, looking at your scope through 1 through 3 emissions and thinking about how you might set decarbonization targets, implement more sustainable working practices. But as well, it looks at issues such as how to deal with employees, lawyers within your firm themselves, particularly if they are having potential ethical issues with regards to advising certain clients. Now, we do not go so far as to say at any point that lawyers should not be advising certain high-emitting clients, but we do outline that lawyers, at least in England and Wales, are allowed to decline instruction on the basis of various principles, one of which being they're able to decline to advise if it conflicts with their own personal beliefs. Now, this does not apply in criminal cases. It only applies in civil. And indeed, it only applies even then in an absolute fraction of cases. But we did think it was important to lay out what the regulatory position is on this political and quite hot topic. And in part B, we go down to really what kind of John's initial question was in terms of, well, how does this affect lawyers' duties? What does competency look like in a warming environment? And the answer to this question lay in us examining the various duties lawyers are bound by in England and Wales, and that includes the duty to act in their best interest of their client, the duty to warn their client of relevant risks and opportunities associated with the client matter, and as well to disclose it in a manner which those risks to the client in a way which they can understand. Now, if we understand that climate change is impacting various areas, particularly if you think you're, for instance, corporate transaction lawyer, of course, climate change is going to be relevant in terms of the subject matter of the transaction and perhaps as well in terms of the client intentions and perhaps broader aspirations they might have as a business. But indeed as well, it exists on the very kind of private, personal circumstance of perhaps even buying a property. And thinking about how climate change is impacting the environment itself and how that then might impact asset valuation, insurance availability, and all these various considerations, which then also form part of the lawyer's advice. So we issued that guidance. It has a little bit of a section as well on the ethical principles which lawyers are bound by and thinking around acting in best interests of your client and acting with integrity and what that means in the context of greenwashing. But with all of this then established, what we have seen, what I think is quite exciting to share with American colleagues, is that when we published the guidance in 2023, we're now, over 12 months out from the guidance being published. We got a great response. We'd worked with, countless lawyers in various different practice areas on producing the guidance, not just environmental or climate change experts, but also with other industry bodies and such. But we saw a really good, warm uptake from the profession on this issue, and the dialogue is continuing. The fact I'm speaking here to you today, I hope, is indicative of that. And what we see now, again, a relatively personal anecdote, but now when I speak to some lawyers, even those in small to medium-sized practices outside of any large city in rural areas, what we would term high street practitioners, are starting to advise their clients on these exact issues. And that can be less than 5 partner law firms all the way up to 50 plus, multinational law firms advising on it too. So this is really relevant for everyone. It's not just relevant for environmental lawyers, and clients care about this issue. In terms of what's next, what we can flag is an area that we've been dialing down into a little bit more, to the point I made around this being high-level guidance, which addresses the profession as full. We recognize post-publishing that guidance, certain areas of the profession, for instance, corporate law, said to us, we need a little bit more detail as to what these duties mean in the context of advising a board. We want to know what these duties mean in the context of a real estate transaction. And we've produced guidance in those areas. So we have a piece of guidance as well on climate risk governance and advising directors on greenwashing and corporate due diligence in the context of climate change. That can be passed on in terms of the supplementary materials to this talk. And indeed as well, on top of that as well, we are working on we're currently doing a consultation on a specific practice note on how climate change is impacting real estate transactions in England and Wales, a kind of maybe large difference between the United States and the United Kingdom on this front is, whilst obviously it's extremely regrettable right now what is going on in the United States in terms of extreme weather events, in the United Kingdom, that is not something that we tend to ever encounter. But as climate change is becoming more profound, what we are seeing are where people think that climate change is something that occurs perhaps in the global south or in other countries, it's starting to impact both residential and commercial properties, and clients and lawyers are beginning to care more about this issue. And it is really highlighting the necessity of a lawyer who sits within a real estate transaction as the only advisor who's acting within the best interest of their client, and therefore acts as a really key personal advisor to them as to whether that property which they're aiming to purchase and hopefully sell, pass on, or whatever it might be in years to come, thinking about bringing climate change considerations, whether that be new regulations or legislations, which might impact, energy performance, EV charging points or whatever, all the way to, adaptation of the property itself to extreme weather events, flooding, coastal erosion, subsidence, etc. The lawyer can provide advice on this. And that's why it's absolutely fundamental that we see climate change competent lawyering being mainstreamed throughout the legal profession, hopefully in England and Wales, and hopefully as well beyond in the United States as well. So thank you all for listening to my remarks today, and happy to pick up the dialogue and hope to see progression continuing in this space. Thank you.